Council, ladies and gentlemen, I see that everyone is here, so we can continue with the final phase of our sentencing hearing, which is my decision on the sentence to issue in Mr. ALMEDA's case. He has pled guilty to murder in the second degree, and as is well known now after argument from counsel, the range of the sentence for that offense gives me considerable discretion, because the range is from 10 years to serve to 99 years. No specific aggravators or mitigators are applicable, although they can apply by analogy, which is what has been argued to me in this case. At least the state has asked for a parole restriction if I impose a sentence on the higher end of the scale, presumably, which is what they're asking. Let me first begin, as I do in all of my sentences, with a discussion of my preparation, the record I've reviewed, and perhaps it's more important in this situation because I have been off the bench since September 1st and came back to finish this case. It was not expected that it would take this long to finish the case, and I think it's important if there's any further proceedings for anyone reviewing my sentence to know what I reviewed in preparation for today. Of course, I reviewed the file and the materials that I was engaged in prior to the proceedings over the last 2 days, and in particular, they included what have been referred to by the attorneys as the 404B proceedings, and that is those arguments before me that certain evidence related to conduct of Mr. ALMEDA toward prior women that he had relationships with during his high school years should be admitted at trial. Most of that conduct did not result in arrest. None of it resulted in convictions. And I issued an order prior to Mr. ALMEDA's plea about what information should be included. The materials on that were considerable. They included transcripts, documents, of course, looked at my order and the briefing that was supplied me in that case. I reviewed the pre-sentence materials. They were substantial. Anyone seeing me carry the file into this courtroom can see that the pre-sentence file is a couple of inches thick, and most of that included over 200 letters that were submitted by members of the public, members of the Moore family, some from Mr. ALMEDA's family, about the case, more particularly what kind of sentence I should issue. They took, I'm going to say, days to read, because they took longer than a full day of reading for me to read. I placed different weight on those letters for sentencing purposes. Some of those were important to me because they came from what I consider to be the victims most directly impacted in the case, the immediate family members, and they also provided some of the information most helpful to me, that is information about Bree Moore herself, or information about Mr. Almeida, or information about their relationship, or information that would help me piece together what might have happened that day. Secondly, there were letters from many of Bree Moore's friends at high school or on her volleyball team, but friends who knew her, and in some cases who knew Mr. Almeida, and they gave me some insight into both of those individuals, and again, a helpful understanding of both of them, and therefore a helpful understanding on events that could have occurred that evening, and also an understanding about how their relationship might have fit or not fit with how I perceived Mr. Almeida's relationships with other women in the past. Then there were many letters that just came from the public, some of which I didn't place very much weight on at all, in the sense only that they didn't provide helpful information to me, except for urging a particular sentence or expressing outrage and community condemnation at the homicide, a condemnation which I could almost presume from the volume of material that I received. I reviewed all of the new materials that came in recently, those being the sentencing briefs from the parties. The briefs from the state included new materials that I hadn't previously seen, some forensic reports, autopsy photos, crime scene photos, 911 tape, interviews with Mr. Almeida, but considerable new factual information. Of course, I reviewed Dr. Zelig's report, which had been prepared before his testimony yesterday, including the two sets of background exhibits he had with his report. Then there were the additional exhibits that came in during the weekend and the hearings yesterday that I simply had to review overnight before we completed the evidentiary portions, and those were copies of logs, of texts between Bree and Josh, some new medical journal articles about borderline personality disorder, additional crime scene photos, and some other supplemental materials, but those were all reviewed by me. Additionally, I took one extra step because of what I saw as such a significant disparity in the sentences argued to me by both parties, and that is I went back and tried to pull as many files as I could remember from second-degree murder cases that I sentenced while I was an active judge, to see if I could find any similarity, get any feeling of consistency. I'm a believer in consistency in sentencing. If there were cases or a case that I felt was comparable. It seemed important to me to find it. I will say that of the half a dozen cases that I had sentenced defendants on second-degree murder, I was through the range. I went anywhere from 30 years to serve to 99 years to serve with a restriction on parole until the defendant was 70 years old. So I was the full range, and the crimes were so different that I found, frankly, little assistance. But I did that preparation before the hearing. I've, of course, considered the testimony of Dr. Zelig yesterday. I find that Dr. Zelig is a credible witness. Finding that he's a credible witness is not also finding that I concluded that he persuaded me in all of his testimony. He did not, as I will explain later. I've listened to, of course, all of the oral statements made to me this morning and considered them as well, and of course the arguments of counsel, which, as you could tell from how long they took, I thought about beforehand and had many questions regarding, and then Mr. Almeida's statement as well. Sentencing requires me to make various findings on certain statutory factors referred to as by lawyers and judges as the Cheney criteria. They're now a list of 7 considerations that are enumerated by statute as well. But I should start with the last of them because the courtroom was so emotionally filled this morning, and that last consideration is one of restoration to the victim or victims. And I've said this before in homicide cases, I will say it this afternoon as well. This morning was grief-filled, is all I can say. And there is nothing that I will say or do in the next hour that can ameliorate that grief. I have to follow a different path here. As much as I am not at all insensitive to that grief, in a sense, must make my decision based on the factors that require me to see through and beyond it in a certain way, and to stay true to what the law asks me to do. Not easy. Not easy when I sit through a morning like I did today. And while I know how hard it was for people to stand and speak before me today, and while, as I said, it was a morning of excruciating emotion, I must be guided by principle and fairness. A certain amount of compassion, law, fact. And so with that, let me begin with those other sentencing factors. And I'm going to talk about those before I talk by analogy and make findings on the specific aggravators in the worst offender finding that counsel have asked of me, and then the parole restriction that have been asked. There are two of the sentencing factors that address the offense itself. One is just the seriousness of the offense in relation to other offenses, and secondly, it's the circumstances of the offense. And let me discuss the facts that address both of those. The seriousness of the offense is self-evident. This is a homicide. It's a gun crime. And it doesn't get any more serious when somebody's life is taken. So it ranks right up there on the top of the serious level, and of course the sentence reflects that. And the fact that even with second-degree murder, I'm authorized to give a sentence equivalent to first-degree murder reflects that both degrees of homicide are treated with equal seriousness under the law. As to the circumstances of this particular offense, I find that there are facts that, when enumerated, make them very serious and really push them to the edge, or maybe over the edge of second-degree homicide. And they are these. First, without looking at the shooting itself and how it might have happened, and I concede that there's We don't know for sure what happened. What we do know is Josh ALMEDA shouldn't have been drinking. He shouldn't have had a gun. He was on probation. He had a history of gun violence, and he should not have been there drunk with a gun in his hand in the first place. And whether it would have been an assault with a gun, or as it turned out, a homicide with a gun, those facts, and he just left treatment a few hours ago and decided to blow it off and celebrate by getting really exceedingly drunk, with a history of knowing that and being told by others and others who love him that he's a bad, mean drunk when he drinks too much. He sort of did it anyway. And that's regardless of whatever happened with the shooting itself. And those circumstances, in my view, make this, the circumstances of this offense serious and really push it to the edge of recklessly indifferent murder. And then I have to ask myself, well, let's take a degree of recklessly indifferent murder. Certainly if you pick up a gun and point it at somebody and the gun goes off, however, that's definitely recklessly indifferent to the value of human life, and that's your classic second-degree murder. Doing with that when you're drunk makes it worse. Doing that when you ought to should have known that the gun was loaded, and I find that Mr. ALMEDA should have known that because he's played with guns before. By his own statement to me today, he was dismantling that gun and putting it back together again, and I do not find it credible that he could have picked up that gun and not known it was loaded. That makes it worse. And in my mind, pulling the trigger when someone has had the time to throw up their hands and try and protect themselves. And the evidence supports that conclusion. However Bree Moore was standing or sitting or lying in bed, she threw up her hands and tried to protect herself from the shooting. That took an instant in time. But in that instant in time, that happened before that trigger was pulled and the bullet left that 9mm Glock. And in that instant in time, that's enough time for Mr. ALMEDA to have thought about what he was doing, and that pushes this over the edge to me. And terms of the seriousness and the circumstances of this offense. It's certainly not made any better that this was a domestic shooting, but the combination of guns and alcohol when they shouldn't have been in play in the first place, and the facts that, in my mind, certainly suggest a deliberate act by Mr. ALMEDA in this case. Even as drunk as he clearly was at the time, given that he was the only one drinking and there was literally little alcohol left in that Captain Morgan's rum bottle. As I said, make this extremely serious second-degree murder, in my view. I agree, there are a lot of first-degree murders that are a lot worse. And I've seen them. I've had them in my courtroom, and they are a lot worse. But as far as second-degree murder goes, this is really pushing the limits, in my view. Next is a required discussion of the defendant's criminal history and rehabilitative potential. I'll take them one at a time in Mr. ALMEDA's case. Mr. ALMEDA's criminal history is problematic in two respects. By number and nature, he accumulated 7 misdemeanors and his felony in a pretty short period of time, just a couple of years before the homicide in this case, and was under one or another form of probation for the last 2 years before this happened, and continued to get into trouble as his criminal history reflects, albeit on a misdemeanor level, but seemed to get into trouble literally every couple of months for a while. And nothing seemed to be at all deterring him or working for him. In fact, committing one offense immediately after a court appearance on a prior conviction of his. The other aspect of his criminal history that's troubling is the relationship of alcohol to his offenses. Alcohol played a large role in 6 of 7 or 5 of 6 of his offenses. And that, as Dr. Zellig testified, particularly troubling for a man who was diagnosed with the condition that he had. And when that criminal history is also set with his non-criminal history, but his relationship problems with the women he was dating, And some of those problems involved, as my questions reflected today, emotional manipulation, threats with weapons, in one case, an arrest, a discharge of a weapon, and subsequent acquittal at trial, but still at least 3 relationships where I found in my prior order his emotional or physical manipulation or violence in circumstances was sufficiently probative of what would have occurred in this case, that what might have occurred in this case, that it would have been inadmissible at trial. And I believe now, having seen evidence of the emails the text messages between Mr. Almeida and Ms. Moore leading up to the shooting, I would have reaffirmed the probative value of those events, because I view and so find that those text messages reflect more than him being just a jerk. It reflects an emotional codependence or manipulation that also seemed to be a characteristic of his prior relationships with earlier girlfriends that they rejected and wished to disassociate themselves with, because they, in one way, found the entanglement distrustful or threatening, but reasons that they broke off the relationship with him. I've since learned through the testimony of Dr. Zelig that the emotional dependence, the impulsivity, the anger, the outbursts, that is reflective of the criminal conduct at his arrests and convictions show, and his association with his girlfriends reflect, is consistent with this borderline personality disorder that he was diagnosed with. And that ties into the question of his rehabilitative potential. And I find that it's extremely poor in the short term and guarded in the long term. Dr. Zelig found, and I find this one of his findings to be believable because of the various risk evaluations he conducted and Mr. Alameda's test scores on those evaluations, some of which I'm familiar with from prior cases, that even for the next 10 years, he's at a significant risk of reoffending. And a particularly high risk if his alcohol problem is not addressed and under control, a substance abuse problem that Dr. Zelig called horrible. I concur. It's for someone as young as he is, it's horrible. And combined with this borderline personality disorder, he presents a risky individual, and I worry about his risk as a somewhat uneducated judge because of Dr. Zelig's conclusion that Mr. ALMEDA met as many as 8 of the 9 criteria for this particular condition, which, despite its name, borderline, which implies like maybe it's a marginal condition, is not. It's a very serious, dangerous psychological disability that, if untreated, leads, as Mr. ALMEDA's past conduct reflects, to unpredictable outbursts of anger, and if you combine those with alcohol and you combine those with a weapon, then injury. And in this one case, as we've seen already, death. It's a serious condition, and if untreated, the question I've been struggling with throughout 2 days of testimony is this condition going to magically go away as Mr. ALMEDA matures? I find, based on doubts that I have regarding Dr. Zelig's testimony and some of the literature and review of some of the literature that's been provided to me, contrary to some of the things that Dr. Zelig testified to, that we just don't know and can't be assured that it's just going to go away. The reason I find that is that literature is so general, and Mr. ALMEDA's situation is really specific. And my finding has to be specific, and the parole board's assurance 25 years from now, 10 years from now, 50 years from now is a specific assessment. I can't be sure. I don't know. I will say, in my experience, I have seen offenders change from the day of sentencing to 5 years, 10 years later. Some have changed for the good. Some have changed for the bad. I don't know what's going to happen to Mr. ALMEDA. That's why I say his rehabilitative potential is guarded. But it is clear that it will remain risky unless his alcohol treatment is addressed outside the prison setting. B, that his borderline personality disorder is also addressed, which I also think can't happen until it's outside the prison setting. And in any event, he's a risk for the next decade or two. Which raises the issue of the need to confine Mr. ALMEDA, and for how long? States asked for a considerable amount of time because of the parole restriction they've sought. And Dr. Zellick has said even for the short term, he ought to be confined. There does, in my view, need to be a serious and substantial need of confinement in Mr. ALMEDA's case. First, simply because it's a homicide, and in my view, a borderline deliberate one. Secondly, he presents somebody who right now is at serious risk of reoffense. I'm not of the view that he's going to age out of his criminal behavior as I would think ordinarily for someone as young as he is. I am of the view that because of his condition, although treatable, that it's a condition that makes him very risky in terms of his dangerousness. Secondly, in his short history with his experience with the criminal justice system, he's already demonstrated that probation and the rules don't apply to him. It's as I began with, he shouldn't have had a gun. He shouldn't have been drinking. These things were all self-evident to him years ago, and years before this event happened. And he just kept on, and whether it's related to his condition or whether or not, in my view, he was not taking any of it seriously, and if that's the case, and he's indicated that the non-confinement alternatives don't work, then it's going to be the confinement alternative, and it's going to be a long confinement if you shoot your girlfriend. I'm always required to address deterrence, and I've been urged to consider the deterrent value of a sentence, because certainly this can be classified as a domestic violence homicide because of the relationship that Ms. Moore and Mr. ALMEDA were in. I wish that long sentences in homicide would deter those homicides from occurring, but as anyone knows who reads newspapers, domestic violence homicides are our most popular homicide. They continue to happen by the hundreds every year around this country. I'm not sure that a sentence I will issue today will stop anyone from the impulsive, drunken, reckless conduct that Mr. Almeida engaged in. It might deter him from ever doing it again, and I'm entitled to consider that, and I do want to deter him from doing that again and make sure that it doesn't happen again. But the deterrent value of sentences we issue, I sometimes question. I try to issue them in fairness, as well as, I guess, considering all of the factors and balancing them. I am required to consider community condemnation. I've always looked at that sentencing criteria as community condemnation about the nature of the crime and not community condemnation about the particular crime. Because if it was community condemnation about the particular crime, then we would sentence defendants more harshly depending on the victims who screamed the loudest about what happened to them, and that would not be a fair result for our judicial system. But there nonetheless is, I think, significant general community condemnation for this particular crime. And in the beginning I said, you know, I put various value on the letters that I received, and I got a lot from the general public, and some of it I didn't put much value on. But I remember one of the letters I received from somebody who didn't know either Ms. Moore or Mr. Almeida, and it started off using some fairly strong language to me about what I should do. And I was about to just sort of turn the page and think, oh, you know, he's one of those people who just feels really strongly about, so strongly about stuff, his language, da-da-da-da. And then at the bottom, it's sort of, well, let me paraphrase what he said. It was sort of like, Judge, you may be of a different generation, but even though I'm only 22, I know that you never, ever point a gun at anyone, especially a woman, and pull the trigger. And I was struck by that because sometimes I think I'm old school because the way I grew up, you know, they were hunting rifles, nobody had handguns. And so I'm amazed in this day and age when everybody's around with a handgun, and so I get outraged sometimes when people use them, and sometimes I think my reaction to that is out of the mainstream of community condemnation. But here is somebody who is Mr. Almeida's peer and Ms. Moore's peer saying, I know that this is something that you never, ever, ever do. And that reflects a degree of condemnation, I think, for this event that should be reflected in my sentencing. And I take that to heart. I mean, I'm not saying that that gentleman speaks for the entire community. That's Mr. Myovis's job, but I was struck by that as a chord about this particular crime, that maybe I'm not off base in thinking that that's not something you ever do, that even there's a younger generation of Alaskans here who feel strongly that that's just not appropriate behavior. And is something that should be appropriately condemned in a way. There are certain aggravating and mitigating factors that are applicable to presumptive sentencing that don't apply to discretionary sentencing, such as in a homicide case like this, but they are applicable by analogy. They help a court weigh an offense, and there are certain circumstances here that were urged as aggravating and mitigating factors, and I'll make findings in them as follows in the order that I rank them. I do find, as my discussion reflected, that this is a most serious second-degree murder. I just it's over the edge, in my view. I gave it a lot of thought. I had been thinking about it for days, really since I picked up this file on Friday. I knew it was an issue. It's been very troubling, one for me, but this combination of, as I mentioned, alcohol, drugs, and just the circumstances of the shooting, which are, in my mind, indicative of a much more deliberate act than anything that's just simply reckless, push it over the edge to me. And so I do find it's more serious. By saying so, I'm not making any specific finding about where Ms. Moore was standing, what may have prompted the shooting, whether it was just an outburst by him, whether she told him she was leaving, whether they had a petty dispute, whether he used some language on her like he used in their text, and she had some words with him about it, whether he was suddenly feeling insecure, whether it was a murder-suicide. I'm not making any of those findings, but I am making the finding that it was closer to a deliberate shooting than a reckless one, for the reasons that I stated in the circumstances of the case, and for the reasons that he shouldn't have had the gun, he shouldn't have had the alcohol, he shouldn't have placed himself in that circumstance at all, and that he was just leaving treatment, etc. Secondly, Mr. I find that Mr. Almeida has a history of not only assaultive behavior in terms of his criminal history, but he has a history of very troubling relationships with his girlfriends in the past, and I stand on the discussion in my order and my findings in my order. His conduct with his prior girlfriends, although granted it was not physically assaultive, is very disturbing in the sense of what it says about his view of his own self-esteem and his view of women and his manipulation in relationships and what I would call his emotional abuse. And it was troubling to me when I did the order. It's more troubling to me now, seeing even more evidence. And so those two factors, in my mind, make me convinced that there's that history that supports aggravator C8. The third aggravator that I find, and it would rank number 3 in terms of my weight, is that he was on probation when this occurred. He was granted an SIS. I mean, he had all the opportunities to discharge a felony conviction as a young man, and instead he's drinking and he has a gun. Not only is he not following probation, but he's making the situation worse, and so I place greater weight on that aggravator than I would on the fact that this was a dating relationship. It troubles me more that he shouldn't have been drinking and shouldn't have had the gun at all than the fact that he was in a dating relationship when this happened. So that C18 aggravator is on the bottom. As to the C4, the dangerous instrument aggravator, that's self-evident from the crime. I don't place any weight on it at all. It's hard to commit homicide without a dangerous instrument of some kind, your hands, a vehicle, a knife, a gun. I don't place any weight on it, so it's there, but I'm not placing any weight on it at all. I struggled also with the question of whether or not Mr. Almeida is a worst offender. I've made that finding many times, not many, but I've made that finding before. Used to making it with offenders who've had a longer criminal history than Mr. Almeida. I know what the law says about my ability to make that finding, both in terms of the offense and the criminal history of the defendant. But I do find that as he sits here now, he is, in my view, and I do so because of his history of his offenses and his inability to correct his behavior when either informal or formal probation has been applied to him, combined with the frequency of his criminal acts, combined with the impulsivity and aggression of his criminal acts, especially when it's viewed also through the lens of the periodic, while all of this is happening, manipulative, threatening conduct with girlfriends going on. It reflected a pattern of what I would call dangerous conduct for a young man that made him risky in light of his condition to me, and without anyone able to have a crystal ball, was clearly leading up to something, in my view, much more explosive, and it happened. And his lack of follow-through with treatment, more than his lack of follow-through, he just didn't do it at all. And his disregard for the tools that were given to him by the criminal justice system, by his family, I think it makes him a worse offender, and I view that term not because he's worse, because the offenses that he does are the worst, but that he's worse because he's harder to correct. And that's certainly what I see with Mr. ALMEDA. That being said, I decline to find that, even though I believe this is a more serious murder too, and I believe that Mr. ALMEDA is an offender that's very difficult to correct. I am not going to order a parole restriction on his sentence. I don't have a crystal ball, and if I order a parole restriction and I'm wrong, I could make a grave mistake. If I don't, of course, I could too. But the parole board at least will be able to hear what I've said here today and incorporate that in their decision. He is a young man, and he is going to be in jail for a considerable period of time, and changing and maturing. As I said, he will come out of this either better or worse. I don't know which way. That's going to be up to him. And if he comes out of it better, then he certainly he should have the opportunity to demonstrate that. And I shouldn't take that opportunity away from him, in my view, because I think then I take away the opportunity for him to demonstrate that. I am going to require this, however. And that is before he is released on discretionary parole. And I'm ordering it because of my concern about principally his borderline personality disorder, and whether or not by then he will actually have had adequate substance abuse treatment or abstinence long enough, that he be evaluated by a trained psychologist or other forensic professional who can assess whether or not his borderline personality disorder is in any degree of remission, and to what extent, and also assess his risk for recidivism upon release by whatever tools or tests are then available and currently acceptable in the profession. My Cheney criteria, as I've discussed them, have almost all of them all weighed in favor of a heavier sentence. It always weighs heavily on me when I have a young man in front of me, young defendant in front of me, man or woman, when I go through the numbers, as it were, and I conclude that the sentence must be on the longer end of the scale when I pick up the pieces and put them on one end of the scale or another, and it tips in one way, and I've done that here, and they tip in favor of a long sentence. I also, as I said, I reviewed my prior sentences, and the times when I went way to the end, they were crimes that were distinguishable from this one in their degree of either premeditation, deliberateness, or meanness, as it were. And I declined to accept the state's urging to sentence Mr. Almeida at the far end of the range, and I also decline the defendant's urging for a sentence that in my mind would release Mr. Almeida at a point in time where I'd be worried about his dangerousness, and one that would, in my mind, not reflect the seriousness of the crime and the seriousness of his situation and his risk. I therefore sentence Mr. Almeida to 75 years flat. As I said, I decline to issue any restrictions on his parole eligibility. He, of course, will be credited for time served, the usual assessments for court costs and others will apply. Mr. Lambert, you are private, are you not?
Yes.
I know that fingerprinting remains. Other issues, counsel?
Judge, I don't know if we can do this today, but one of the things I would very much like to make sure that everything is brought to closure today. In discussing this, I realize we still have the outstanding SIS for the mixed 4. I don't know if there's anything you can do about that today. I would be prepared for the SIS to be revoked and you impose the minimum sentence that you can.
I don't represent him on that.
Okay, I didn't know if that was the case or not.
I don't represent him on that.
That's fine. We're going to have to resolve that.
Okay.
Judge, the only other thing was Ms. Moore did write a letter as well that she read today. And one of the things that OVR wanted me to make sure is that that does get attached as an addendum, and it's also part of the public file as well for this case.
And we just need to keep her to submit a new pre-sentence report.
Yes, I will. I'll send.
The sentencing memorandum attached to it.
I will. I can take care of that. I usually send a letter directing her what to do, and I can myself remove the sentencing memos from Mr. Moore's letter, so they're not included. But as to the corrections in the pre-sentence report, I'll send her a letter telling her what to do so she issues a new one completely, and it doesn't include my write-ups on it.
Right, I just didn't want her copy to go to the probation or parole,
Right.
or parole board.
No,
And following his institutional file with those attached to him.
no, they won't until it.
Your Honor, I have a copy for the court's record, a public file of Ms. Moore's statement. Mr.
Okay.
Moore will I also like to have his statement as part of the public record in addition to already being in the PSR, Mr. Moore's letter. And I want to make sure that the court has the stipulation regarding the
I did.
piece of evidence.
I wrote order. It is so ordered on it and signed it.
Okay, thank you. Good. I just want to check on that. Thank you.
Okay.
Is it? I don't know if there's going to be restitution claimed or not, Judge, but can we address what time frame you would like that to be submitted to the court in the event that there is?
I usually give the state 90 days.
Okay.
And require, if there is restitution claim, to submit any supporting documentation of the claim to defense counsel.
Understood, Judge. That's all the state has. Thank you very much for your patience.
Okay. Fingerprinting.
Judge, what's the, assuming that Mr. Almeida wanted to appeal the sentence and your findings, I think you need to provide that information.
I'm sorry, Mr. Almeida, I am required to tell you this, and I should do it on record while they're preparing their fingerprinting here. You do have a right to appeal my sentence, and the time frame from that is 30 days after the judgment is issued. That's not going to happen today. The judgment has to be prepared by someone here in the court system, and I will sign it, or another judge will sign it on my behalf after I review it and make sure it's what I say. And you'll get a copy of it through Mr. Lambert, and it'll have a date on it. And 30 days from the date of that is when you have to file your notice of appeal. You have a right to have a court-appointed attorney if you can't afford one and you want to appeal the sentence. And one will be appointed for you if you wish. But what you also should know is that even if you want that, because Mr. Lambert, for instance, can't continue to represent you, he has the obligation until one of those court-appointed attorneys comes in on the case to make sure that your paperwork gets into the Court of Appeals on time. So if there's a delay in the court-appointed attorney, he will file that notice of appeal for you. But usually the court-appointed attorneys get there on time. But if you want to appeal the sentence, and somebody from the Public Defender's Office or the Office of Public Advocacy hasn't contacted you, if Mr. Lambert can't represent you on the appeal, then you let Mr. Lambert know that you want to do that, and he will file what's called a notice of appeal, and that will preserve your right to appeal. You understand? Any questions? And all you need to do is if he can't represent you, then all you need to do is tell him you want a court-appointed attorney, and he'll set things in motion, so that'll happen. Okay? Any questions?
No, Your Honor.
Okay. I am in review of the fingerprint verification form that Mr. Almeida has completed. Prints are legible. It's been signed and witnessed and dated. Unless there's nothing further, we will go off record. Counsel, everyone, just go about your business. I have to clean things up here. As you know, this is not my normal space.
Thank you, Your Honor.